And Michigan news headlines today. Jennifer and James Crumbley will be sentenced for their roles in their son's 2021 mass shooting. Ethan Crumbley pleaded guilty to killing 4 classmates and injuring 7 others at Oxford High School. He is serving a life sentence without parole. Now, prosecutors have asked the judge to sentence each parent to 10 to 15 years in prison after their convictions for involuntary manslaughter. Attorneys have asked that the parents be sentenced to less than 5 years each. James Crumbley's attorney asked the judge to sentence his client to either 28 months or 42 months with credit for time served. Jennifer Crumbley's attorney asked the judge to follow a guideline of 29 to 57 months with credit for time served. Jennifer also wants to be allowed to serve her sentence at her attorney's home under court supervision.
And this has been a deeply emotional case since the beginning. And it's now in its final step for the families impacted and the Oxford community.
To break down what we could see at the Crumbley parent sentencing, we welcome in attorney Jamie White. Jamie, good morning. Welcome to Good Day Northern Michigan.
Morning, guys. Thanks for having me.
So a couple of interesting things about this. I mean, we have both attorneys for both parents asking for different sentences, but obviously less than prosecutors are asking for. Give us your take as we head into sentencing, which could happen here this morning.
Yeah, so sentencings are always extremely difficult for the community to understand. You know, for one, it's a 15-year maximum, but by law, you are only allowed to be served initially the 2/3 of your sentence. So 10 years is the absolute max the judge could do in this case. There also is the issue of guidelines, which up until about 10 years ago were mandatory, where certain factors would come into play, and then the judge had to stick to those guidelines. That's changed. They do have discretion now. I do not expect these folks to get 10 years. I'm not saying I don't think they deserve it. But I don't expect that. I think the idea that the mother will be put under house arrest is extremely absurd. But I think that the recommended ranges that you discussed in the beginning of your outtake are probably what we're looking at, 2 to 3 years with some term of supervised release.
Now, Jamie, that in that explanation, that was the thing that immediately piqued my curiosity. Why would someone not house arrest at their own home, house arrest at their attorney's house? Something about just requesting that seems incredibly fishy.
It's bizarre. It's certainly, you know, I mean, I've been doing this 25 years and I've never heard of such a thing. I don't even let my clients know what my first name is. I'm Mr. White. You know, so the idea that somebody would come live at my home for a period of incarceration is extremely, to use your words, fishy. It's certainly suspect, and I do not expect this particular judge to entertain anything of that nature.
Well, it raised a question for me about Jennifer's attorney as well, but aside from that, I mean, the involuntary manslaughter charge is not breaking new ground by any stretch, but again, as we've talked before with you, the parents being charged in a school shooting is breaking new ground. Does that present any other, I don't know if pressure is the word, but any other pressure on the judge to make a stance on the parents in this case? And would it have any future implications for a sentencing, you know, down the road in the event something like this happens again?
You know, so that's a great question, and I think that it's a two-piece answer. You know, part of our judicial process, the prosecutor in this case has really gone out on a limb and prosecuting these parents for what we've talked about before, the community not really taking responsibility for, you know, these extraordinarily negligent actions on the part of parents and oftentimes school officials. However, it is the role of the judge to be objective, and you know, there certainly is going to be pressure to maybe go over the skis, so to speak, but I expect a reasonable sentence based on their backgrounds, based on their individual participation in these events or lack of participation in these events. And I think the recommended guidelines are probably going to we're going to be looking at a 3 to 4 year sentence. She is not going to be living with her attorney. That I will gamble on, and I don't gamble.
Yeah, it seemed far-fetched, frankly. But I know we've chatted about this previously, but do you think that this is going to almost, because there wasn't really a playbook, but write a playbook for how parents are held accountable in the future for tragedies like this?
I do. I think this has been a long day coming. You know, I've always been a proponent, even on the most simple level. You know, many moons ago, I was a school teacher, and, you know, kids would not appear in school for months at a time, you know, young children. And to me, that just was negligent on the level that required some criminal prosecution, because that kid or young person is going to ultimately present consequences to the community associated with that neglect. Now, here we have a situation that is very, very more significant. And again, you know, I have a home in northern Michigan. I know you guys, I'm a hunter, but I can tell you this much. It will take a nuclear bomb to get into my gun room. And the idea that a parent would allow a mentally challenged young person not only access, but to buy him a weapon is something very, very different. And I think prosecutors all over the country are looking at this, and there's going to be future prosecutions along these lines.
Well, Jamie, we appreciate your insight as always. That verdict
Yes,
could come down at any time. Only sorry it didn't happen while we had you on the air live. But thanks again for your take on this, and we'll appreciate catching up with you next time, Jamie.
Good seeing you guys. Take care.
Thanks so much,
Bye-bye.
Jamie. You take it
well.
easy.
All right.